Just as lenders and companies had started to come to terms with the new Insolvency and Bankruptcy Code, the RBI lobbed them a surprise. The banking regulator killed all earlier debt restructuring schemes and replaced them with the Resolution of Stressed Assets revised framework. Well, that's a mouthful, and most people refer to it as the February 12th RBI circular. Lawyers that have worked on many debt restructurings say it's a life-changing circular. Shivani Saxena finds out why.
CDR, SDR, JLF, S4A. In the last 15 years, the Reserve Bank of India introduced several schemes to help restructure corporate debt. But there were very few successes. In 2016, the Parliament enacted the Insolvency and Bankruptcy Code. The code laid down clear processes and tight deadlines for insolvency resolution and liquidation. Even that didn't move the lenders or corporate borrowers much, till in June 2017, when the RBI ordered banks to file insolvency cases against 12 large non-performing accounts. Suddenly, the threat of insolvency and liquidation proceedings made the mouthful of restructuring schemes more attractive, until February 12, 2018, when the RBI suddenly pronounced these schemes dead.
One of the biggest critiques that I've seen of this new framework from banks is that what the RBI ought to have provided a transitionary period, in that a lot of banks, and I at least know of 40 to 50 different cases, were at the last stages of trying to restructure their loans, whether it was under the SDR mechanism, outside SDR, or the S4A mechanism. This new framework has just been introduced on the 12th of February, and there is no transition period which has been provided. So even if they provided a 30-day transition period for banks to actually successfully manage to complete restructuring under the previous regimes, that would have been helpful. So it's a mixed reaction between shock and getting together to what to do next.
On February 12, the RBI withdrew all previous schemes and replaced them with Resolution of Stressed Assets revised framework. This framework is different from the earlier schemes on at least 3 counts. The revised scheme permits lenders to restructure debt flexibly in any manner, whereas earlier each of the schemes were permitted to be used in certain circumstances with certain prescriptions, whether it was modification of loan terms or conversion of debt into equity. For instance, restructuring under S4A was only applicable to projects that have begun operations. There is no such requirement under the revised scheme. The revised scheme seeks to include all banks and financial institutions except regional rural banks. The earlier schemes primarily catered to domestic financial creditors. The revised scheme also includes a stringent 180-day timeline for implementation of restructuring, failing which, the lenders in case of debt over 2,000 crore rupees will mandatorily have to resort to the IBC. On the other hand, restructuring timelines in the earlier regimes were not as stringent nor the consequences as drastic.
Under the earlier schemes, which were more prescriptive, so long as you could meet the conditions, there was no defined time frame within which you had to put together the package and implement them thereafter. But however, the law is now prescribed, the RBI has prescribed a 6-month time frame from the date of a default to complete this exercise and achieve a minimum level of credit rating. Given the complexities associated with doing a restructuring, which is consensual, bilateral, and requires a number of stakeholders to be carried together, it is going to be a tough task to achieve any restructuring, and that too, that will achieve a minimum level of credit rating within a short span of time, say 6 months.
The time frame may not look so bad when compared to the IBC timeline of 180 days for insolvency resolution, extendable to 270 days. But timelines aside, the revised scheme introduces new procedural requirements as well. Now, in the case of a company with debt over 100 crores, all debt will have to be independently evaluated by an authorized credit rating agency. Companies with debt over 500 crores will need 2 such evaluations. Also, if a restructuring under the revised scheme involves change in ownership of the debtor company, then the new owner must be eligible under Section 29A of the Insolvency and Bankruptcy Code. 29A is the section that debars willful defaulters, promoters of non-performing assets, and persons connected to them for purchasing those assets. If the acquirer doesn't meet the criteria set out in Section 29A, then the lending bank will not be able to upgrade the loan account to standard, which may prevent the bank from accepting such a restructuring.
If you are a promoter who's disqualified under 29A of the IBC, you cannot actually participate in a pre-IBC scenario, which seems to be an extension of the IBC law to a situation when the company has not even been taken into insolvency. I think that's a little harsh because there will be various promoters across different sectors who may have one particular company in insolvency. What this effectively does is that debars them from participating in a restructuring even prior to IBC. So they've taken the law which is applicable to IBC and indeed the spirit of the IBC and applied it at a much earlier time.
This, the experts say, has impacted several restructuring schemes that were near closure prior to the introduction of the revised framework.
There were a number of examples of transactions that were in the pipeline, which were either on the lines of an S4A or an SDR, or even in some cases people were contemplating a deep restructuring. However, once the new circular has sort of come in, the focus on many of those transactions will be to see whether those transactions can result in a situation where you could meet the basic credit rating criteria that has been put in place. So there are still companies who are trying to do a restructuring or a resolution within the framework of the new circular. However, the parameters are pretty strict and the timelines are very tight as well.
But there's also the view that the combination of revised framework and the IBC could spell good news for sophisticated buyers of stressed assets.
This is also a great opportunity for stressed funds and strategic investors who were not investing in the market simply because they did not have a determined timeline within which they could acquire the stressed asset. Over here, the banks are now incentivized to not go into the IBC process because under the IBC process, it's the resolution professional who takes over and not the promoters. So the access to the promoters' business acumen, or however you sort of consider that, it is not available to the banks any longer, and it's the resolution professional who takes it. So there is a 180-day period now prior to insolvency, which is a definite period within which a stressed fund or a strategic investor who's looking at a specific company could actually quickly buy out the assets.
The February 12th circular may be challenging, but at the same time, it is likely to incentivize all stakeholders, whether promoters or lenders, to finally agree on how to deal with the stressed asset. Experts are confident that the revised framework will be the ultimate push that finally leads to resolution of the non-performing assets. That is, unless the RBI has certain surprises in the days to come. This is Shivani Saxena for Bloomberg Quint, Mumbai.
Whether the fear of insolvency will lead to lenders expediting restructurings will be known once the 6-month timeline expires. But if that doesn't happen, the tribunals will get flooded with even more insolvency cases, which begs the question, are we giving NCLTs more than what they can chew? Well, that's all that we have on this week's show. Do send us your feedback. Thanks so much for watching. We'll see you next week.